Good morning, all. Thanks for having us here today. It truly is a team approach, I'm convinced, to making sure that the businesses that relocate, the executives that relocate to West Michigan, or our West Michigan-based companies that are doing business internationally, it really is a team approach to assure that success. So what I'd like to do today with our time is give you practical advice. We'll give you we can give you the legal sites as well, but give you some practical advice and insight into the immigration law world. The Congressional Research Service, I want to say 6 years ago, came out with a study that held that immigration laws then exceeded the complexity of our tax laws. It's a bit of a patchwork quilt of far from logical provisions. Many provisions conflict, and if you've been watching the news at all, it's a political hot potato. So having the prospects of meaningful reform, at least in the short term, are, well, I'm not going to hold my breath. We'll just say that. But I'm going to maybe break the rules a little bit. I know we have question and answer time at the end, but if there's key points or an issue that any of you want clarified, I'll watch the clock, but I'll certainly take some questions during the presentation. That's something our general counsel makes me put in there. There's enough of that. Even us partners have rules we have to follow. But just kind of hitting on some of the things that Tim had said and Nunano had said is, if you put this little pressure on all of us, the executives that are often coming over to help set up this new U.S. operation or a key staff addition, those are key to some major projects. It's key to the growth of many of the organizations that the Right Place has worked with. And one of the major failings is housing, is settlement, or we call it the inability to unpack their suitcase. So all of you play a key role in helping that success. Us lawyers are known for telling war stories, so if you'll indulge me, I'll have one quick one here. It brings to point, I think, the key issues we're trying to cover today. I had a client that was moving from distributorships to a manufacturing operation in West Michigan, and they'd spent a lot of time with the commercial relocation experts, settled in West Michigan, had a great team that they were building here in the U.S., had an executive that they took months to convince to move over from Germany to just outside of Kalamazoo. And it was critical. I was told it was critical that we gain permanent residence, the green card for this individual quickly. He had children that were in their late teens. They would, from an immigration law standpoint, age out if they hit 21 and couldn't get the green card with the family. So my office, my staff, we were under this pressure to get the green card in place. We accomplished that mission. And right around the 1 year mark of this plant, I got a bit of a panic call from one of the owners overseas in Germany about this executive's decision to move back to Germany. What would that do with the green card? Could we have him go back and forth? Issues on the replacement. I got to know the executive a bit socially. My wife and I both did. They didn't have a lot of outside contacts here. So that was my next call to Oregon, asking him, I thought things were going well here. The company's doing great. And he said, well, his wife, Rosemary, she just couldn't get settled in here. And so I started asking why. And I'm not faulting the realtor because they were following directions. But Oregon and his wife bought this beautiful home in an executive community, large 4 or 5 acre lots, quite a ways out of town. And this was, you got to make, it's like who was making the decision what the decision should be. Coming from Germany and living in a municipality, they didn't have the opportunity for large homes back in Germany. So their first impression was, this is the place we want to be, not thinking through that Rosemary, who doesn't work, and as the kids are now off to college, she's there on her 5-acre estate all by herself with no friends and not the easiest ability to make friends. So the happy ending of the story is, why don't you sell this place? Why don't you look at one of these other, condominiums, a beautiful condominium in town where she can meet friends, doing a lot of work with German nationals. There's a German club that hooked her up with that. She got some friends. They stay. They're doing great. Eugen recently retired, and the plant doubled in size about a year and a half ago. So a potential bad war story where the location, as in real estate's location, where the location of that first home purchase was almost a major setback for this growing international company in Michigan. So what you guys do is certainly very important. What I want to do is help you with those tasks. I still see a number of issues come up with sophisticated realty groups, with sophisticated lenders. And so my mission in part today is try to overcome, maybe demystify some of the verbiage. Immigration law tends to have its own language. But just a couple of issues that can add to the complexity, can arise with some complications. The U.S., although it's not necessarily as easy as it used to be, but there's still relative ease of business travel. Most of our trading partners, most of our Western European, EU countries don't even need a visa. They don't have to go to the consulate. They can get what's called a visa waiver program and come here for certain permitted activities, not everything. They can come here for business meetings. They can come to explore educational opportunities, but that's typically a 90-day stay. They cannot work. They cannot engage in actual U.S. employment, a job that's a true U.S. employment opportunity. Sometimes that line's a bit fuzzy, to say the least, or not clear. When does it cross over from permitted business activities to U.S. employment? We see that often with our friends to the north, or Canadians, where they'll come here and I'll have to, what are you coming for? Well, I'm looking at some land with the right place for it. Well, that's fine. I'm closing on the land. That could be fine. Are you going back soon? Still working at the Canadian operation. So it kind of goes case by case, but that's where we can see some problems. Or I'll get a panic call at the border. The guys at the border aren't letting me through. Well, what did you tell them? Well, I told them I was coming over meetings. They asked me where I'm living, and I told them I bought this house in Spring Lake. That was the problem. And I said, did you tell me you still own your house in Canada yet? And your wife and kids? No, let me talk to the officer, and sometimes we can get through that. But that's an example of the guys and gals at the border are trying to make that assessment in far less time than we've all been talking this morning. Has this crossed over or exceeded these permitted activities? Because even our Canadian friends under NAFTA have this similar restrictions on what they can and cannot do. So some careful preparation and issue spotting from the whole team is important. The longer term stays, maybe just as an aside, the visa waiver program, depending on what the individual is doing, we even see with students, for example, it's perfectly legal. If mom and dad don't like the dorms, you get great dorms there at Calvin, but if mom and dad don't want their son or daughter living in the dorms and they want to buy a house, it's perfectly legal for that foreign national who has no intent to immigrate to the United States, just their children are going to go to school here. I've seen them buy houses. That's perfectly legal to do. It can present some challenges with the lenders if there's going to be a mortgage involved, but it's a perfectly legal transaction. You can work through the financing. Often there's some cash payment opportunities. Don't shy away from those opportunities whatsoever. So the visa issues. The visa issues take time. They can, in certain circumstances, be expedited. There are often times where we can get our immigration work done before any of you can locate and close on that house. There are some visas we actually can get in 30-day time frame, and sometimes even less. Most visas that are going to authorize U.S. employment in that longer-term stay are really a two-step process. So we're filing centrally with an Immigration Regional Service Office petition, employment-based. We have to get that petition approved, and then the individual will go to their home country, the U.S. consulate in their home country, and have to go through an interview, screening everyone's criminal history background check. International databases are checked, as well as to make sure that person is who he or she says they are. And it's also the first opportunity for an officer to see actual documents. Everything I file will be copies. So it is that two-step process. And certainly in this post-9/11 world, we do see delays at the consulate level. And I can almost predict and usually will forewarn our clients that if they have a very common last name, there's going to be, quote, database hits. Your last name is Gonzalez Gomez, or if your last name is Mohammed, there are going to be people with that last name that are on databases and going to cause some delay to confirm that the people on those databases that we may not want to allow in the United States are not the individual sitting in front of that consular official. Our government, our consular officials, in their view, a 3-week, 4-week, even a 6-week time frame, in their mind, as an expeditious resolution of those database hits. So that's something we have to deal with at times. So just some issue spotting. The other thing I wanted to address is give you some means of addressing the lender issues that may arise, or concerns that you myself as a realtor may have. So what we see as concerns are, if someone says, I have a visa, there may be restrictions on that work authorization. What does that mean? Most visas, employment-based visas, we'll actually talk about the alphabet soup, if you will, are employer-specific, so they're restricted to that employer, or they're restricted as to time. Until someone gets that green card, that permanent resident status in time, there's a time restriction. But those are generally readily renewable or can be extended, so it should not pose a barrier to our housing search or to the lenders. Immigration sponsorship. You may hear someone says, well, I'm waiting for my immigration sponsorship to come through. That's just another way of saying their employer actually has to do the petition for them. And typically that's a well-vetted process. If the employer has extended that job offer, they're working on a relocation. Typically they're already dealing with immigration counsel, and we've mapped out the process for them. So that should not be something that scares us away from helping with that housing search. We'll talk to the questions of what does an employment-based visa do, or what does it mean to wait on immigration benefits. So those are some of the issues that can come up. The how long, my office, frankly, we are open and willing and encourage the realtors and lenders to call us. I regularly write, letters that I sign and tell them here's the process. We have an H-1B visa for Ms. Upton, and we're working on her green card, and she meets all the criteria, and I'll sign my name that I'm confident she will have that visa and work authorization. She'll be scheduled to start on time. No reason not to go forward with house closing. So that's something that many of us immigration lawyers will certainly are willing to do. And if, on the other hand, the immigration lawyer is not willing to do that, then that certainly may be cause to push back that closing date, or tell your friends at the mortgage operation that, they may want to have that carefully screened by their underwriters. But most of us, if we have a clear path forward, we'll tell you what that is in understandable terms. So yes, the process can take long, can take weeks, can take months potentially, but usually we can give you some estimations on that time frame. There are options certainly to address those timing issues. I don't do it, but the real estate lawyers in my office will. We have power of attorneys. We've actually sat in on the closing and signed the documents for someone who can't break away from their current obligations abroad. So it's a way of handling that closing without forcing the individual to make a trip just for the purpose of that closing. There are other means of addressing those issues by, again, watching those timings, talking with immigration counsel when will the individual be able to close? When do you think you'll have that paperwork in place? Additional risk liabilities, aside from their normal due diligence of any credit risk, there really shouldn't be any. None of us have guaranteed employment. Spent quite a bit of time in the employment law area as well. Michigan's an at-will state, so none of us have this guarantee of long-term employment here. So to look at the H-1B visa or an L visa or any of these other classes that have a 2-year term or a 3-year term or a 5-year term, that should not be a barrier to, well, how can we give somebody a 15-year mortgage if their visa is only good for 3 years? The employment plans typically are indefinite long-term. Our visas are just issued in certain increments. But again, in most cases, certainly readily renewable. But good questions to ask. There are certain banking laws I won't get into where certain reports and databases have to be checked, but that's no different than any international banking relationships. And our major banks are well versed at that. So there's certainly no legal reasons that any of us should be shying away from helping with that housing search as a realtor or encouraging our lender friends to underwrite those loans. I'm not going to repeat all the answers, but there's some issues there, answers to some of the issues that are on the slides. One other maybe quick aside on the mortgage issue, a good segue for Dr. Upton. Cultural awareness, as Nana had mentioned. There are many cultures, people of a Muslim faith in particular, that do not want to or will not borrow money with interest. So that obviously can be a major problem. But my friends in the real estate practice certainly are well versed, and many of you know that land contract terms certainly can be an option. And we have individuals. I had a physician client that I was working with, and he was telling me where he was buying a home, and it wasn't the neighborhood that I would expect a neurosurgeon to buy a home in. He says, "Well, I need to pay cash." And I said, "Well, not really. You could do a land contract." And what's a land contract? So we hooked him up with one of our real estate lawyers, and his broker went back to the housing search, and they didn't move into that very Spartan neighborhood, and found him a home. The land contract was much more in keeping with his current income and income potential. That's an area where if you don't have that cultural sensitivity, many people that are of the Muslim faith, they will not borrow an interest. You build that into the land contract, that's fine with them. So just something to keep in mind. So I've already mentioned a few of these terms, and you may run into them in dealing with the international or foreign national client. So those of you may run into something called a B1 or a B2 visa. The B1 class, these are just paragraphs of the law. Look at the Immigration Naturalization Act, the various sections, and there's paragraphs under the non-immigrant visa category. Some paragraph B1 happens to be business visitors. Some paragraph B2 is tourism and pleasure. So those who are required to have a visa, who can't come here into the visa waiver program, they're exploring business opportunities, exploring employment opportunities, would have that B1 visa in their passport. That is not a work authorizing visa, but that may be used for that initial trip, attend board meetings, explore employment opportunities. An E1 and the E2 class, Tim and his team at the right place are a good source of these visas. These are treaty trader, treaty investor visas. So depending on the relationship between the foreign company and the new U.S. operation, if it's trade-based, we have treaty trader visa options. If it's investment-based, we have the E2 class, again, second paragraph, investor class. These visas cover both the owners that may be actually putting the money in place for the investment, but it also covers their senior management team and something called a specialized knowledge worker or an essential skill worker. So it'd be even less than someone with a college degree. It could be someone who we need an E2 essential skill worker for someone that was a critical IT person. They had somewhat limited formal education, but had all the latest certificates, were critical team member on the SAP rollout. This was a global company that used SAP, and the new U.S. company was being opened. They wanted that SAP platform as well. And so we use an E2 there. So there's quite a variety there. E3, by trade agreement, our friends in Australia, at their professional level, Australian nationals, have that E3 option. The H-1B is the specialized knowledge occupation worker. It's probably the most commonly used visas for the IT professionals. It has wide application. We can use H-1Bs for physicians, for physical therapists, many in the medical field. It requires, in general, a 4-year degree, U.S. baccalaureate degree, or a foreign equivalent. We often call it H-1B season in April. Many employers are subject to an annual cap, quota, an annual fiscal year quota. Government fiscal year starts October 1. By law, by regulation, we can file for new H-1Bs April 1. So we literally will have a mass filing April 1. And this year, like last year, we ran out of our annual quota, and that first, they gave us a week of filing. And we do a random selection of who gets their H-1Bs. Not the best business development model to tell clients they invest $5,000, $6,000 in an H-1B application. It's down to a random drawing. Some employers, fortunately, nonprofits, many of the hospitals are nonprofits because they have teaching clinics or a program for teaching physicians. They are also cap exempt. So we do have some opportunity with the nonprofits. On the educational world, they're cap exempt from that quota as well. But the H-1B is probably the most common one you'll see. And also the most common one for our international students that transition from a student visa to a longer-term stay with broader work authorization. That's the H-1B. So you'll probably see a lot of H-1Bs when you're dealing with the international client base. The H-2, it's an employment-based visa. You probably will not see a lot of that because by its nature, it is a seasonal 1-year maximum visa. We see a lot in the tourism industry where larger groups of H-2s will be filed. There's an H-2A for agriculture, a bit unwieldy for the agricultural industry because of the advanced planning and trying to figure out when planting season, when is harvest season, and building that all in. So it's there on paper, but our agricultural client base is not that thrilled with the H-2A. That's what an H-2B worker is. It's temporary or seasonal. The H-3, we've seen increased use of the H-3 trainee. Typically, that's an 18-month maximum. So maybe looking for rental property versus a home purchase. The H-3, we've seen increased use because of our H-1B caps and quotas. So if we can't get someone in H-1B to come to the United States or to stay here, we've increasingly utilized that H-3 to take our Calvin grad, put them here in the U.S. for up to an 18-month initial training and assign. Then we'll send them over to the London office for another year of training. Then we'll bring them back. I'll jump ahead often to our L1 intercompany transfer. So you'll see that at times there's kind of a path to getting people back here and staying in the United States. That's what the H-3 is. The J-1 exchange visitor. The J-1 is a fairly broad employment authorizing classification. We have J-1s up at the Van Andel Institute. They have their own J-1 program. They bring in researchers from all over the world. That's a great example of what the J-1 does. We have J-1s at Calvin College. Both students, non-degree seeking students would have a J-1. The degree seeking students would have an F-1 visa. We'll have J-1 guest faculty. You may see a visiting professor here in a J1, and that's how they're here. They're able to work and be authorized to stay. And the times vary. It could be 3 years, it could be 5 years, it could be renewed. So a very broad use with that J1 program. The L1 intercompany transfers, you should asterisk that one or circle that. The L1s are typically our executives with an international or multinational company. They also can be used. There's an L1A for executives and managers. There's an L1B for more of what they call the specialized knowledge worker. Slightly different definition than the H1. But the L1s are also able to fairly expeditiously obtain the green card, the permanent resident status. So I mentioned you may want to start that one, because if they have the L1, often the planning is we do the initial L1 visa, something I can typically obtain in 30 days, 60 days or so, get the foreign national executive here, with the plan that they're going to be seeking the green card, permanent residence down the road. So a good client for all of you to have. The O1, that's probably another one to star. Aliens of extraordinary ability. Those are kind of the rock stars of any given profession, which means large executive homes, often 6 figures and 7-figure salaries. So you may want to highlight that O1. If somebody says they have an O1 visa, yeah, you're going to the high rent district. But the O1s really are intended to bring the best and the brightest of any given field to the United States. Not the easiest piece to accomplish. It is a high bar, but there's actually a fair number of O1s in our community. And they certainly offer significant benefits to our community, be it leading researchers, leading physicians and surgeons. We're working on an O1 right now for an artist and designer, someone who's, I'm not into knitwear, but she's globally famous with her knitwear design. So bringing some talent and growth, economic growth to our community. So the O1s are, we like to see the O1. The R1, that happens to line up, again, it's just paragraph R subparagraph 1 of the Immigration Nationalization Act, but R1s are for religious workers. Some you may guess that would be our ministers, our pastors, our priests. But R1s have broader use than that. R1s can be used really for any profession that the tenets of a faith are attached to the core job duty. So teachers. If we have a teacher at a religious school, we typically can get an R1 for them as well. We've done R1s for publishers and writers, where they are publishing or writing or editing religious faith publications. And so there's certainly a critical element of the faith being part of that. And those are employment authorizing visas, so they can certainly stay longer term. There's a parallel green card or permanent residence classification for the religious workers as well. So often you'll see the R1 worker transition to that green card permanent residence status. TN or NAFTA, TNs for the longest time were a 1-year visa. And so you didn't necessarily see TNs in the real estate world, maybe for rentals. But TNs about 6 years ago to a 3-year option. And here in Michigan, since Canada's so close to us, TNs by definition are for nationals of Canada or Mexico. Well, technically the U.S. to send our U.S. citizens to Canada or Mexico as well. But TNs for treaty NAFTA. They can be issued in 3-year increments now. I don't want to discourage you from selling homes to any TN workers, but the TN by definition is what we call a true non-immigrant visa, meaning the individual has to have an intent to return to their home country. They're not barred from buying a home, but from my view, I'm much happy to hear it's a cottage on the lake, it's a vacation home, I'm buying it now. When I go back to Canada, this will just be our vacation home. If they buy a home and it's not really a vacation property, I have to start looking for, all right, when your TN expires, we can't really renew it because it doesn't look like you're going back anymore. What are we going to transition you to? So it's not that you can't sell them the home, but the TN, by nature, is supposed to have this intent to go back to Mexico, back to Canada. So if you do sell them a home, it's not vacational. Just let us know. We have a little advance warning. So that's kind of your alphabet soup, if you will, of what you're going to run into with this international client base. There's a little broader explanation on each of these in the next slides. I'll just kind of skip through that. Please. Not really. I mean, the short answer, just to maybe repeat the question, that with the sale of real estate with foreign nationals, from a tax perspective, I'm not a tax lawyer, but I know some good ones around town. From a tax perspective, with the foreign national who's not a permanent resident, our tax authorities view that as if that money's leaving the United States. And so that's where they get into a larger withholding requirement. They want to make sure that capital gain often is subject to taxation. So I've seen some good estate and trust planning where if the trust owns it, the trust is a qualified domestic trust, there's ways to ameliorate some of those tax implications. But a good question, something that certainly you want to put on the proverbial radar. Mm-hmm. Yeah, true. Mm. Yeah. Yeah, I don't have a better answer for you than that. Yeah, there's certainly some gaps and some hurdles that we see. We also see on that same point, we now have a procedure. It's supposed to be getting better, but even our approved H-1B, any of these visa holders, even if they have that approval notice, even if the consulate put it in their passport, to get the Social Security number, they have to physically, enter it into the United States. A database from the Department of Homeland Security has to speak to, talk to, transmit something to a database at the Social Security office before they can get that Social Security number. This process, they used to always tell us that it took at least 10 days. I don't know why, but they're saying it's going to get better than that because now most major airports are an electronic scan. You see a little I-94 card paper, and that's all moving electronically now. So apparently with this new electronic I-94 card, the transmission's supposed to be sped up. I'm kind of taking a wait-and-see approach, but it's always a point of frustration that our closing is next week. They're coming in. If we don't schedule it just right, well, you're not going to have a Social Security number in time. It's going to take time. And they don't listen to us. Well, we have a house closing schedule. We need that SSN. Or the underwriting at the mortgage company is giving me fits. We don't have our SSN yet. So just another procedural issue we have to deal with. Is there another hand over here? So again, there's a little more detail on some of these visa classifications, for your leisure reading. Some other classifications you may run into that I didn't mention, not as common, but they can come up. There's an H-2 visa, again, for the seasonal workers. The H-3 we already mentioned. P visas, we have the Griffins in town, the professional athletes. P visas, again, just kind of lined up nicely with the alphabet. But professional athletes, entertainers can get a P visa, so you may see that. And again, the R1 for the religious workers. The green card process, I've already mentioned that a bit. The green card or permanent residence status They are actually a shade of green again. They were a pinkish hue for a long time. But for the longest time, they were green. And by green card, we mean permanent residence or resident alien status. So what that means is they're really no longer subject to the employer sponsorship. Green card status gained through marriage to a U.S. citizen, same thing. They're no longer subject to that relationship. It's an independent right conferred on that individual. And they have the right to reside here permanently and can obtain employment just like a U.S. citizen. They just can't vote or hold elective office. But for all practical purposes, they're paying taxes like everybody else, short of running for office or voting. Some other constitutional rights, they're here for as long as they desire to be here. It is a three-step process, though, and sometimes we're seeing questions, well, I understand they have a pending green card, and we have a house closing coming up. Well, when's it going to be done? The answer is it could be 1 month, 2 months, 3 months, depending on the individual circumstances. The answer could be it's 7, 8, 9 years. We have another quota to deal with this immigration benefit. We have an annual quota on green cards on permanent residence. The law is as old as I am, and I think not as well thought out as I think my thoughts are. But this is a 1965 law that set quotas by country of birth, not country of citizenship, but country of birth. So the last several years, the last decade or so, we've had higher rates of immigration from India and China. And my physician clients from India literally have to expect a 7, 8, 9 year wait to the quotas to get green card in hand. If their colleague was born in neighboring Nepal or Pakistan, I'm getting that green card to that physician in less than 12 months, just because of this country of birth quota. That's one of the, again, not to be too political, but that's one of the issues with immigration reform is, why do we have quotas based on country of birth? Maybe we should look at our true needs here in the United States, business needs, healthcare needs. Nothing against Liechtenstein, but we could take the whole country of Liechtenstein and not hit their quota. But we have to tell physicians or executives from India that it's a 7, 8, 9 year wait to get your green card in hand. And that's probably not a very easy discussion to have with business executives or investors. Well, we'll get you the green card in about 9 years, but put your plan in here today. Yes, so that's something we all need to work on. But just to give you a basic understanding of what's involved, for most employment-based green cards, permanent residence, we start out with a labor certification process. And this has taken various forms on how we get this labor certification. But essentially it comes down to the U.S. Department of Labor reviewing an application, now a little over 12 pages long, depending on our addendums. The standard's 12 pages. We file this electronically, detailing certain regimented or regulated recruitment efforts. And just keep this in mind if any of you are in a hiring or management role. Our requirements for a foreign national to gain the green card require that there's a 30-day recruitment period, and they tell us typically in regulations what kind of recruiting we have to do. So we have to do a 30-day ad with our state unemployment office. We have to do 2 Sunday ads for a major publication journal. And then we have to choose from a list of 10 more and do 3. Typically it's our own website, another job search website, and we can do a weekly job ad or campus recruiting, headhunters, radio, TV, and a few other recruitment methods. So we have to do these mandatory 2 plus 3 more, local commuting distance from the job, and demonstrate that there were not minimally qualified U.S. workers, minimally qualified. And what that means tends to change. When we had 3% unemployment, they kind of took our word for it. When we have 7, 8, 9% double-digit unemployment, they second-guess all these decisions. There's reported decisions. There's something called BALCA, the Bureau of Alien Labor Certification Appeals. They're very busy the last several years. But they have issued decisions the likes of a refusal to hire for a U.S. worker or declaring them not qualified because they had a fisticuff, an altercation at their last employer. So the company seeking labor certification, well, we wouldn't hire anybody who got fired for a physical altercation. And the Department of Labor said, well, that really had nothing to do with the requirements of the job, the education you required, the experience you required. They're qualified for the job. Labor certification denied. So it's a test of whether they're minimally qualified U.S. workers. Only when we demonstrate there are no minimally qualified U.S. workers do we get labor certification. So that takes about, there's a 30-day recruitment period, 30-day applicant response period. We file electronically with the government. They will take 4 months to 6 months on average to review that and to certify this application, unless they audit the application. About 25% of the applications go to audit. Audits take on average about 1 year. So we see lengthy processing times for many of these. So just to give the idea, so when someone's telling you that they're in the context of labor certification or they're in the context of permanent resident status, that doesn't mean they're getting their green card tomorrow. Just make sure they have an H-1B that's in place. You'll be fine with disclosure. There's a chart at the back that kind of summarizes, if you're a visual person, gives you an example of how to take our international student from Calvin into one of these classifications and keep him in the United States. And with that, I'm going to turn it over to Sandra.